The European Commission plans to unify data protection within the European Union with a single law, the General Data Protection Regulation. The current EU Data Protection Directive 95 EC does not consider important aspects like globalization and technological developments like social networks and cloud computing sufficiently and determined that new guidelines for data protection and privacy were required. Therefore, a proposal for a regulation was released on January 25, 2012. Subsequently, numerous amendments have been proposed in the European Parliament and the Council of Ministers. The EU's European Council aims for adoption in late 2014 and the regulation is planned to take effect after a transition period of 2 years. Summary: the proposed new EU data protection regime extends the scope of the EU data protection law to all foreign companies processing data of EU residents. It provides for a harmonization of the data protection regulations throughout the EU, thereby making it easier for non-European companies to comply with these regulations. However, this comes at the cost of a strict data protection compliance regime with severe penalties of up to 2% of worldwide turnover. Note: the current version contains increased fines up to 5%. Content: the proposal for the European Data Protection Regulation contains the following key changes. Scope: the regulation applies if the data controller or processor or the data subject is based in the EU. Furthermore, the regulation also applies to organizations based outside the European Union if they process personal data of EU residents. According to the European Commission, personal data is any information relating to an individual, whether it relates to his or her private, professional or public life. It can be anything from a name, a photo, an email address, bank details, posts on social networking websites, medical information, or a computer unregistered trademark SIP address. Single set of rules: a single set of rules applies to all EU member states and there will be one single data protection authority responsible for each company depending on where the company is based or which DPA it chooses. A European Data Protection Board will coordinate the DPAs. There is an exception for employee data that still might be subject to individual country regulations. Responsibility and accountability: the notice requirements remain and are expanded. They must include the retention time for personal data and contact information for data controller and data protection officer has to be provided. Privacy by design and by default require that data protection is designed into the development of business processes for products and services. Privacy settings are set at a high level by default. Data protection impact assessments have to be conducted when specific risks occur to the rights and freedoms of data subjects. Risk assessment and mitigation is required and a prior approval of the DPA for high risks. Data protection officers are to ensure compliance within organizations. They have to be appointed for all public authorities and for companies processing more than 5,000 data subjects within 12 months. Consent: valid consent must be explicit for data collected and purposes data used. Consent for children under 13 must be given by child unregistered trademark S parent or custodian, and should be verifiable. Data controllers must be able to prove consent, and consent may be withdrawn. Data breaches: the data controller has to notify the DPA without undue delay and, where feasible, not later than 72 hours after having become aware of the data breach. Individuals have to be notified if adverse impact is determined. Sanctions: the following sanctions can be imposed: a warning in writing in cases of first and non-intentional non-compliance, regular periodic data protection audits, a fine up to 100,000 European euros or up to 5% of the annual worldwide turnover in case of an enterprise, whichever is greater. Right to erasure: a so-called right to be forgotten was replaced by a more limited right to erasure in the version of the GDPR adopted by the European Parliament in March 2014. Article 17 provides that the data subject has the right to request erasure of personal data related to him on any one of a number of grounds, including non-compliance with Article 6.1. That includes a case where the legitimate interests of the controller is overridden by the interests or fundamental rights and freedoms of the data subject which require protection of personal data. Data portability: A user shall be able to request a copy of personal data being processed in a format usable by this person and be able to transmit it electronically to another processing system. Timeline. The preliminary schedule is October 21, 2013, European Parliament Committee on Civil Liberties, Justice and Home Affairs had its orientation vote. Ongoing negotiations between European Parliament, Council and Commission, expected adoption in 2015, expected enforcement from 2017, discussion and challenges. The proposal for the new regulation is not final yet and discussions are controversial. Thousands of amendments have been proposed. The single set of rules and the removal of administrative requirements are supposed to save money. But critics point out some issues. The requirement to have a data protection officer is new for many EU countries and criticized by some for its administrative burden. The GDPR was developed with a focus on social networks and cloud providers, but did not consider requirements for handling employee data sufficiently. Data portability is not seen as a key aspect for data protection, but more a functional requirement for social networks and cloud providers. Language and staffing challenges for the data protection authorities. Non-European companies might prefer the UK-Irish DPA because of the English language. This will require extensive resources in those countries. EU citizens no longer have a single DPA to contact for their concerns, but have to deal with the DPA the company chose. Communication problems due to foreign languages have to be expected. The new regulation conflicts with other non-European laws and regulations and practices. Companies in such countries should not be acceptable for processing EU personal data anymore. The biggest challenge might be the implementation of the GDPR in practice. The European Commission and DPAs have to provide sufficient resources and power to enforce the implementation, and a unique level of data protection has to be agreed upon by all European DPAs, since a different interpretation of the regulation might still lead to different levels of privacy. The implementation of the EU GDPR will require comprehensive changes of business practices for companies that did not implement a comparable level of privacy until now. There is already a lack of privacy experts and knowledge as of today, and new requirements might worsen the situation. Therefore, education in data protection and privacy will be a critical factor for the success of the GDPR. References: New Draft European Data Protection Regime Law Group. Retrieved January 3, 2013. In Official Consolidated Version GDPR. Rapporteur Jan-Philipp Albrecht. Retrieved December 9, 2013. Proposal for the EU General Data Protection Regulation. European Commission January 25, 2012. Retrieved January 3, 2013. In Official Consolidated Version GDPR. Rapporteur Jan-Philipp Albrecht. Retrieved December 9, 2013. European Commissioner Unregistered Trademark S press release announcing the proposed comprehensive reform of data protection rules. January 25, 2012. Retrieved January 3, 2013. How the proposed EU data protection regulation is creating a ripple effect worldwide. Judy Schmidt, Florian Stahl. October 11, 2012. Retrieved January 3, 2013. Baldry, Tony. Yarms, Oliver. The Right to be Forgotten. 1 Essex Quarter, European Parliament Legislative Resolution of March 12, 2014 on the proposal for a regulation of the European Parliament and of the Council on the protection of individuals with regard to the processing of personal data and on the free movement of such data. European Parliament. Important facts regarding the GDPR. Jan-Philipp Albrecht. Retrieved July 23, 2013. Overview of amendments. Lobby Plag. Retrieved July 23, 2013. External links: EU Data Protection Page, Procedure 2012 COD, EU Lex, 2012/0011, COD, Personal Data Protection, Processing and Free Movement of Data, European Parliament, How to Prepare for Proposed EU Data Protection Regulation, Overview of Proposed Amendments by Lobby Plag.